Limp Bizkit just suffered a devastating blow in their lawsuit against Universal. I felt like this might be coming based on what has happened. I'm curious to see if Limp Bizkit even keeps going in its lawsuit. If you're new here, what I want to do is just recap where are we at, and then also talk about what just happened. We're actually going to go through the court's order. But if you are new, hi, I'm a lawyer. I've been lawyering for over 10 years. I've been in music myself, essentially since I was 4. I'm very passionate about music business education, so that's why I started this channel. If you're excited, don't forget to subscribe, and let's jump into it. So back in October, Limp Bizkit and Fred Durst had sued Universal, right? One of the largest record labels in the world. And it was a notable lawsuit because of many things, including the alleged failure to pay Limp Bizkit was in the amount of $200 million in unpaid royalties. And then one of the biggest facts here is that we have a band that signed with a label back in the 90s. Now, there were a couple different agreements. We'll go through it. But essentially, Limp Bizkit does its deals in the 90s and then allegedly is claiming as a part of the lawsuit that they have never received a single penny from royalties, which is just pretty jaw-dropping. Now, we kind of speculated on behalf of the label, which we hadn't heard from just yet. Well, if the label was unrecouped, right? That's how this works. You sign with a record label, they become the glorified bank with lots of promises to make you a big star. Allegedly, it all worked out for Limp Bizkit. They became big stars, and the label fronts all the cash. But it's not a gift. Those amounts are recoupable from the earnings from Limp Bizkit's. Usually it's their share of earnings. So it's recoupable one way or another pursuant to the controlling contract. So that's why a band or an artist signed with a label may not actually receive any kind of royalty for a really long time. So then we go, well, if Limp Bizkit has like 3 decades of working with this label and hasn't received any royalties whatsoever, you're telling me that, I don't know, the label must have fronted what, $50 million? The band also claims that Universal had designed and implemented royalty software and systems that were deliberately designed to conceal artist royalties and keep their profits for itself. AKA, Universal's system to just get signed up to get your royalties is such a pain in the butt. It is almost impossible for artists to actually meaningfully use. And I was like, I can at least give my personal experience on this, and that I literally set up one of these accounts for one of my clients because they were kind of having a hard time. It wasn't super intuitive. There were lots of steps. So I'm like, okay, I can see why they're making this claim. And then amongst the giant claims by the band was asking for rescission of the contract. So meaning asking that the contracts essentially be undone, or were in fact already undone, voided, so to speak, because they're like, well, you never paid us anything, and so therefore there's no performance on the contract, therefore we get to get out of the contracts. So then on our last update, what we did is we're like, hey, Universal responded, and Universal filed a motion to dismiss saying, hey, court, for all this long list of reasons, you need to kick out Limp Bizkit's lawsuit altogether. Universal pointed to a whole bunch of things. There's like issues of jurisdiction. Hey, at least pursuant to one of the contracts, they were supposed to bring this in a different court, saying, no, we in fact have paid Limp Bizkit millions and millions of dollars in advances. We'll talk about that. As I was reading through this, I go, look, procedurally, this is how it can just be devastating to a plaintiff. So meaning Limp Bizkit in this case, right out the gate, because if you're successful on a motion for summary judgment, there's also what's called a motion for judgment on the pleadings. You get your case almost entirely thrown out or partially thrown out. We were holding our breaths a little bit for Limp Bizkit, and now we have an update. Okay, so this lawsuit is in the federal court in California, and so this is the court's order. So before the court was a motion to dismiss, which was filed by Universal. Defendant challenges the sufficiency of the complaint and just says, there's a whole bunch of problems with this complaint. So, Your Honor, based on the problems with the complaint itself, we want you to basically just throw this thing out. So the first thing that I'm going to point out is that the court made this decision without oral argument, which again, devastating. The federal court in California reserves the right to do this pursuant to the federal rules of civil procedure, Rule 78, as well as local rules. But anyway, just to be like, look, I have everything that I need based on the papers that everyone has filed, and I'm not going to hear additional oral argument on this. And because there were so many issues, I'm really surprised that the court did this, but obviously the court felt empowered to make this decision. So let's see what the court had to say. All right, Durst is a performer, controlling member of rock band Limp Bizkit, and the owner of Flawless. Plaintiffs' claims revolve around 3 agreements, right? So 3 contracts. 2 of those agreements involve the production, manufacture, distribution of songs, recordings, featuring Limp Bizkit. So there was one in 1996, there was another in December of 2000, and in which case it was actually with Interscope, which is a subsidiary of Universal. So this was the recording agreement under which Interscope released subsequent Limp Bizkit recordings. So the first agreement was the Flip Agreement. The Flip Agreement and its amendments provided that plaintiffs would receive advances on the royalty payments provided for in the Flip Agreement. And then there was a third agreement, which was in 99, and this was an agreement basically tasking Durst and Limp Bizkit to find other acts to sign, right? And then they get a little incentive for doing that. Now, as part of these agreements, what typically comes, especially if it's a band that has negotiating power, and Limp Bizkit was doing real well, right, is an advance. An advance is a lump sum paid by the record label that has to be paid back, aka it's like a loan. And one such advance was $7 million. So we go, well, is it possible that the record label has spent so much money on advances to the band, on marketing over the years, because marketing can be in the millions of dollars per album? According to the complaint, in or around early April of 24, Durst retained new representation and explained that he had not received any money from Universal for any Limp Bizkit exploitations. Plaintiff's new business manager contacted defendant on April 9, 2024, stating that plaintiffs had not received any royalty statements and requesting access to Universal's portal to view them. Now, one of the things in the motion to dismiss that Universal filed that was like, ooh, yikes, is that part of the complaints like, hey, you guys never told us there was money, you haven't paid us anything. And what Universal responded with is like, oh yeah, actually, we reached out to your manager like a year before you filed this thing. And we said, hey, we have money for Durst. We have money for Limp Bizkit. And he said, oh, no, they've sold their rights. And so basically no need to issue the payment. So that was a bit of a yikes, if true. Once plaintiff's business manager viewed the portal and discovered that the accounts had balances of excess of $1.1 million, they requested the funds. Plaintiff responded by requesting that plaintiff fill out forms to receive payment. So this was a part of the complaint. It is normal. It is such a pain in the butt. But a lot of labels, distributors, businesses that you work with, before they send you payment, often they're like, hey, I need you to complete a W-9, send that to me. It usually has, your tax ID or your EIN, has just a couple little details about you so that we can then issue a 1099 to you. So again, it's just these additional steps, these additional forms that have to be filled out, which can make this a struggle to just get your account set up. The complaint also alleges that defendant failed to provide royalty statements for many periods, including all these years, and that the royalty statements reviewed by plaintiff's managers suspiciously show unrecouped balances and what plaintiffs allege are fraudulent accounting practices. I'll tell you, as a practicing music lawyer, record labels and music businesses in general are notorious for inflating expenses, for cooking the books. And where it becomes challenging for us is really in just the financial capacity of someone to take this, right? Not just into a lawsuit, but if you pre-lawsuit want to audit someone's books, you're looking at $5,000, $10,000 to go through that process. So there's just a chain of events that I can speak to, which is you got to start with the contract that actually says you have auditing rights. The statement is supposed to say so many things when they send it to you. Sometimes that all gets missed. So it's, you come back and you're like, I haven't gotten a statement. I'm like, well, your contract says you don't get a statement. That wasn't the case here, okay? So they go, you were required to give us statements. You didn't for all these years. And then the statements that we do see, there's something real suspicious going on. On July 15th, 2024, counsel for plaintiffs sent a letter to Universal alleging that Universal had grossly underpaid plaintiffs with respect with their royalties. Now, here's the thing. There was a demand for payment, and then Universal, which is usually what happens if you hire a lawyer and they send a big scary demand letter, it usually gets someone to do what they were supposed to do in the first place, right? So now Universal's on its toes, and it's like, we're going to release the payment in 1 to 2 weeks. And in fact, they did. And my understanding is that Limp Bizkit and or Durst did not reject the money. It's so important that you don't allow someone to pay you where they're like, oh no, this is the money, here you go. Don't take it. Don't keep it in your account, right? We have to do things to not give the other side an argument to be like, you accepted it. It was acceptance of the payment, which can create issues with arguing, well, it was the wrong amount. I actually don't accept it. You see what I'm saying? The court points to in the contract, there was a 30-day cure period. That's pretty common for entertainment contracts. So they would just say, look, there's not going to be any default or material breach unless we say it to each other and then we give each other an opportunity to cure whatever the problem is. And then, and only then, can there be a claim of a material breach. So the reason this matters to you is because you have to paper your communications. You need to put an email together. You need to have text communications. Meaning if you have a contract and someone's done something they shouldn't, you need to put together notice in a written format, especially if the contract says that you have to do that. On August 26, 2024, which was more than 30 days, Limp Bizkit received over $1 million in back royalties. Flawless also received over $2 million in back profits from Universal. And then plaintiff served defendant with a formal notice of rescission. So saying, look, you have not performed under the contract. We believe that the contracts are void. And if they're void, you no longer have copyright and ownership over the music. So therefore, copyright infringement. Guys, this is a really big piece. There's a mechanism under the Copyright Act for statutory damages, and that's where you get these big buckets of money where they're just set out by law of just if there's willful copyright infringement, we get up to $150,000 per instance of infringement. So then you have a plaintiff who comes along and says, well, therefore I am entitled to $150,000 times all the times you infringed my copyright. So therefore we usually can get up into the millions of dollars. All right, so Limp Bizkit, Durst, in the complaint alleged all these different claims: breach of contract, bad faith, breach of, well, each of the separate agreements, breach of fiduciary duty, copyright infringement, promissory fraud, and then Universal responded with the motion to dismiss. Now, in all those claims that I just went through, you can be in federal court if there is a federal question. So in this case, it's copyright infringement. So that's how we get into federal court. But some of the state law claims, they carry into the federal court, even though it really should be heard by like a state court. But there's jurisdiction in order for the court to hear everything because they're like, hey, judicial efficiency, we need to do it all together. So that's how that happens. So here in the court's analysis, the parties agree that viability of the copyright claim, which is the sole basis for the court's subject matter jurisdiction, depends on whether the complaint's rescission claim is viable. Indeed, in response to the court's order to show cause why it should exercise supplemental jurisdiction over the state law claims, defendants stated that the court should dismiss the rescission claim for failure to state a claim. The court goes on, plaintiff seeks rescission of the contracts that have governed the parties' relationship for almost 30 years because the agreements should be rescinded as fraudulently induced because Universal never had any intention to comply with its contractual obligations to pay royalties. And then the court cites to the Ninth Circuit, so under federal and state law, a material breach of a licensing agreement gives rise to a right of rescission. So just meaning this really can happen. So it allows the non-breaching party, so in this case it would be Limp Bizkit, to terminate because they're like, hey, the other side didn't do what they were going to do. They didn't do what they promised. At all. But a breach will justify rescission of a licensing agreement only when it is of so material and substantial to a nature that it affects the very essence of the contract and serves to defeat the object of the parties. The breach must constitute a total failure in the performance of the contract. So the court goes on in its order to point to the fact that, Universal had paid millions in actual dollars to the band, right? We have signing bonuses, we have other things being paid. So the court concludes that it cannot come to this total failure, no performance whatsoever, because there was performance to a degree. So unfortunately, the band loses on that claim. And then because the copyright infringement claims were based on the rescission claims, those unfortunately are being dismissed as well. Now, the 12 other claims weren't specifically addressed in the court's order, but what the court did is to say, look, as it relates to these 3 claims, we're going to give you an opportunity to amend your complaint. And this is in order to actually litigate, to keep the case in federal court, because we lose copyright, we're out, we got to go to state court now and essentially start over. Now, again, We talked about you sign with a record label. Industry standard is that when you sign with a record label, the deal is that you are giving ownership to your music to the record label. And so that's why it was really important. If these recording agreements could be voided, rescinded, then the band Durst gets the ownership of the music back, which is a huge deal. Even for, our biggest rock stars, our Taylor Swifts of the world, at some point they look back and they go, I really wish I owned my music. And here's the thing. Limp Bizkit already had a huge uphill battle, specifically with that claim of rescission, to say that there has been no performance whatsoever by Universal, because obviously they've been doing something. I would imagine that Limp Bizkit may have wanted to bring these claims earlier, such as in the first decade of the relationship, if there truly had been no performance. But I mean, for a band that sold, 45 million records throughout their career, of course, it was absolutely shocking to hear that the band had not received any royalties whatsoever from its record label. So as it relates to just now, we have what's left over is essentially you didn't account properly, you've withheld allegedly something like $200 million of royalties that you should have been paying to us. You also intentionally designed and implemented an accounting system that is impossible for us to use. And there was this bigger comment about it's not just us. We think that this is implemented for this reason of preventing a more widespread inability for artists on the Universal platform to receive their royalties. So all that to say, Limp Bizkit is not completely down and out, okay? So they have two things that are going to happen here. One, their attorney is going to scramble and try to figure out a basis to reassert copyright infringement claims because the court said, no can do. We're not going to rescind the contracts. So then what would it be? Well, if you're going to assert copyright infringement, it would be, did at any point Universal exercise rights, maybe to the composition, not the actual sound recordings that Universal owns, but the side that would be retained by Durst, by Limp Bizkit, which would be the composition side. If I'm this attorney and I want to keep this case in federal court, I'm going to be scrambling. But it's not just the federal court thing. It's the what are our damages? Because it's going to be now you're limited to proving that there's been spaghetti accounting, as I like to say, fraudulent misrepresentations, the inflating of the books. So it becomes a matter of becoming extremely strategic now. And this is why these motions to dismiss can be so devastating right at the front of the case. Now, here's the thing. The pot of money for the statutory damages related to copyright infringement may be gone. The attorney can't come up with a new reason to say there's copyright infringement. Fine, those are out. But if Limp Bizkit is correct, and in fact there has been a withholding of something like $200 million in royalties, well, there you go. And it becomes very much just strategy of does it make sense for us to continue, because litigation is extremely expensive and it's taxing on you as well from a mental, emotional kind of standpoint. I'm really curious to hear what you guys think. I mean, is this it for Limp Bizkit? Leave a comment down below. I'll see you guys on the next one. I'm Tommy's attorney, Miss Crystal.